Please be seated. Good afternoon, counsel. Let me call your case. This is case IC160026. Stephanie Kniffen Wildeman. Did I pronounce that right?
Close enough.
What's the correct way?
Kniffen Wildeman.
Kniffen Wildeman, okay. Versus the Industrial Commission et al. This is the time set for oral argument. Welcome to our court. Let me just cover a couple of ground rules with you that you may already be aware of. You each have 20 minutes to present your argument. And let's see, are you Mr. Hauer?
I am, Your Honor.
Okay, so I'm wrong. So Mr. Montrose?
Yes, sir.
Mr. Montrose, you can set aside 5 minutes for rebuttal if you wish. Just let us know. You can keep track of the time with the counters on the podium. We've read everything. We've read the briefs. We're familiar with the records, so keep that in mind as you make your arguments. You do not have to use every single minute. I'm not suggesting anything to you. I'm just saying you don't have to use all 20 minutes. We are very familiar with the case. Apart from that, I would advise you that these proceedings are being recorded. They're uploaded to our website, so anybody who goes to the Division I website can view these arguments, and we want you to be aware of that. With that being said, Mr. Montrose, your argument?
Thank you.
And let me just thank the bailiff today, Ms. Schultz, for that crisp admonishment of the gavel. It's excellent. Thank you. Go ahead, counsel.
Good afternoon. May it please the court. My name is Weston Montrose. I'm the attorney representing the appellant, Stephanie Wildeman. She's the injured worker in this workers' compensation case. And as I'm sure you know, what we're here to talk about is ARS 23-1061J. We call these J requests, a request for an investigation and a hearing under the workers' compensation system. And as you know, my problem with what the judge did is I feel that he abused his discretion because he dismissed my request for a referral for a hearing because I didn't attach a medical report or some sort of document. Now, the record shows that there were documents attached. And I'll get to that in a moment. But what's really interesting, I think, about this case is where's the defendant insurance company here? They chose not to submit a brief. In fact, they didn't ask the judge to do this. They didn't ask the judge to dismiss my request for hearing, and they've not even chosen to show up. And Mr. Hauer here, representing the legal division at the Industrial Commission, in their brief, it seems like they don't even want to defend what the judge did in this case. They've taken no position based on what the judge did in my particular case. And in my particular case, I feel that the judge did abuse his discretion. I'll talk a little bit about that. But really what I'm asking this court for is an opinion and guidance of what the standard is to trigger a hearing request under the J standard.
Is this a problem that you think happens a lot?
It is, and because the J request for hearing is very prevalent and it's very important in the workers' compensation system. These claims are administered by notices of claim status or an award by the commission, and when those formal documents are issued, an injured worker has a system to request a hearing and 90 days to do that. And those hearing requests, by the way, take almost nothing.
Are they rejected frequently?
No, they're not. In fact, you can write on a request for hearing, I don't agree. I think I should get more money. They shouldn't have done that. But what you need to do is you need to have the name of the parties, you need to have the case name, you need to cite it, it needs to be dated. It just has to have very, very minimal notice.
I want to follow up on what Judge Spahn just asked you, though. That type of informal requests, those are routinely granted. They're not routinely rejected, are they?
That's true. They're not routinely rejected.
I'm just
So
asking.
while the ALJ may have made a mistake here, this hasn't occurred to us as a systemic problem, at least in the body of cases that we see.
Sure. I think that this is going to be more prevalent, and I alluded to this in my brief, that the Industrial Commission and the workers' compensation system has now incorporated an evidence-based medicine standard of using this, what they call the ODG, the Official Disability Guidelines. And it actually comes into play here in this case, because that's how I found out that my client was being denied some medical treatment that her chiropractor had requested. So the ODG is now the system that claim representatives are using as a frontline way to filter a request.
That's beyond the scope of this case, right? Whatever standards they're using, this is just about whether a hearing should have been granted.
Yes. Judge Swan, I was trying to address your question to me about is this prevalent? Mm-hmm. And it does happen, and I think it's going to happen more because of the adoption of the ODG and the reliance of claim reps on the ODG system and issuing these utilization review documents, such as the one that I attached to my request for hearing. This is often how I find out as a practitioner that medical treatment is being denied. And the judge in this case, for whatever reason, I mean, he thought that wasn't good enough for me to put the parties on notice of what my complaint was. And I do think that these utilization review documents, this should be one standard that should be clear. A utilization review document should be sufficient to trigger a request for hearing. It states the name of the parties, it explains what was requested, it explains that this utilization review took place, and it's denied. That was sufficient alone. But what I'm trying to argue for is even more than that. What I'm trying to argue for is that even that's not necessary. No document is necessary to trigger a request.
Do we have occasion in this case to reach such a result or issue an opinion just describing what might be necessary in hypothetical cases? It's really, your concern is for your client and your case.
Yes.
And you make a good argument that a hearing was required here, but I don't know if that provides a touchstone for us to start effectively legislating what will work and what won't work in cases that aren't before us.
It's interesting. I would argue, though, that the legislative process would be what the commission should have to institute if they want to require documentation in connection with a request for hearing. Other statutes in the same section, such as a petition to reopen, require a document. So, Judge, what I'm asking for is a clarification and guidance, not as a matter of legislation, but as a matter of civil procedure, as a matter of procedure analogous to the civil rules of procedure. For example, Rule 8, the well-pled complaint rule, that's the kind of rule that I think should be announced here. And if there's going to be a screening process, such as the commission suggests that they have this gatekeeping function for Jays, that screening process, that kind of discretion should be similar to like a 12B6 analysis.
Okay, Mr. Montrose, we understand. Anything further you want to argue about this case, the merits of this case?
Yes. So I did eventually get to a hearing on the merits when a closure notice was issued. The carrier conducted their IME and closed the case, and I was able to then get my hearing by filing a request for hearing, protesting the closure. But the problem here is that it was justice denied. Justice denied because it was delayed. And that was wrong for my client. And, as I stand here today, I guess the argument could be made, well, it's moot. You got your day in court. You get to argue the merits. But for these injured workers, not just my client, getting this treatment promptly is the difference between getting better and going back to work. Or if we're talking about financial benefits, failure to pay temporary compensation, it's the difference between paying the mortgage, paying rent, feeding your children. And this is why it's systematically important to consider the bigger picture here, not just Mrs. Wildeman, because these injured workers need to have a clear guidance, and what we really need is a clarification of the procedure and a declaration simply that 1061J has no such requirement for a document, that there's no reason to apply any standard to it other than a well-pled complaint style standard, and that it's abuse of discretion to do otherwise unless the commission chooses to have the statute amended or goes through the formal rulemaking process to change the rules of procedure through the Arizona Administrative Code. But they just can't adopt these standards without going that route. Or it delays and therefore denies justice to the injured worker community.
Is the adoption of a standard properly before us on this record?
Well, I mean, I did argue these kinds of things in my brief.
Right, but I don't see anything in the, because this came to a halt at such an early stage, the hearing was denied. I don't see anything in the record that gives us the ability to comment on the adoption of standards. I appreciate that you're telling us this, and I don't doubt that you're telling us the truth, but I don't know that the issue of the adoption of standards is properly before us at this time.
Okay. There was a recent case about civil procedure and Rule 8 and 12b6 style analysis, Cullen versus Auto Owners Insurance Company,
Not
Supreme Court
anymore.
case. I'm sorry?
Not that recent anymore.
Okay. I mean, I was looking at the case, and the reason I bring it up is because when I was looking at it, it seems to me that that's what the court was doing there, too. They were doing what I'm asking, this court to do, which is that you do have the authority to issue an opinion about what is the procedure, how does
Sure.
ARS 23.
Sure, but
Yeah.
what I'm saying is the rejection of the hearing was not accompanied by an explanation that said, under our new evidence-based, and by the way, I hate the term evidence-based, but that's not your fault. Under our new evidence-based standards, you don't cut the mustard. That wasn't the reason stated for denying the hearing. It may be something that you rightly suspect played a part, but we don't know that.
I recollect the judge, in dismissing the hearing, said it was because I didn't attach documentation, medical documentation or some other documentation. That was the reason Judge Macesso gave for dismissing the
Right.
hearing.
And so if there's an absence of the requirement for documentation in the statute, then it's possible to say the statute doesn't contain the requirement that apparently existed here. But that stops well short of talking about whatever rubrics the Commission might adopt when thinking about these cases.
I suppose, if you're talking about like the claims manual or some sort of internal judicial memo about what they're going to do and how they're going to process these things.
We don't know.
There is a claims manual, and I did reference it in my brief, and it, of course, because I referenced it, says nothing about you need a document or any medical document to trigger this J request for hearing. I guess my concern is that without this kind of guidance, without, the court announcing that the statute does not and cannot contain such a documentary standard, that it's ripe for continued abuse by the gatekeeper, whoever's filling that function at the Commission. And because these things, because...
Is there any lawfully authorized gatekeeping function for these hearings?
Yeah, there is, and the defendants, in fairness, cite to this, and it's in the J statute itself. It says the Commission shall investigate and review any claim in which it appears to the Commission that the claimant has not been granted the benefits, and then it discusses submitting it for a hearing. So I think...
I don't see that as a gatekeeping function. I see that as an independent obligation to investigate.
Oh,
but I guess what I'm asking is, are you aware of any authority that says anyone can act as a gatekeeper in deciding whether or not there will be a hearing upon request?
I think it's a fair interpretation. I'll let Mr. Hauer address that question more so than myself. But I think a fair interpretation of the statute does direct the Commission to do what they did in my case. They sent a letter to the insurance company, what about this? To which they responded, yeah, we know about that. We're denying the medical. That's fair. That's the investigation to find out. Sometimes, as Mr. Hauer's brief points out, the response could be, we granted those benefits yesterday. Okay, we don't need a hearing. So I think that's a fair interpretation of the J statute to conduct some gatekeeping.
So you think then if the Commission looked at the letter from the insurance company and said, wow, the insurance company has pretty good grounds for what it's done here, it could deny a hearing?
No, I think then that they would have to look at the complaint and apply that 12b-6 standard to it. If the plaintiff, the applicant, can, if what they're saying can be proven somehow, then we have a legitimate dispute here, and that evidence should be heard and weighed by a judge on the merits.
Your remedy in this case, now your client has received the treatment now? Is that, do I understand that correctly?
No, as we stand here today, we're still litigating that issue, but we're doing it in the context of the claim was finally closed by the independent medical exam.
So she's still looking to have a hearing regarding the denial of the additional treatment?
Yeah,
Yes.
Your remedy, however late it is in this case, is a hearing.
Yes.
So vacating the award, which is the denial, is what you want still?
Yes, I think that's appropriate,
Right, no, I just wanted to be clear.
but I want more than that because that doesn't solve the problem.
I understand that you want more.
Okay.
I just wanted to clarify that.
Thank you. I'll reserve the balance of my time for rebuttal.
Hold on, do you have any questions, Judge Rossi?
I apologize
All
for
right.
That's okay.
jumping the gun.
That's okay.
Okay. Mr. Hauer?
May it please the Court, my name is Jonathan Hauer, and I represent the Industrial Commission of Arizona. The Industrial Commission of Arizona was not a litigant in this matter. Instead, it issued the decision that is on appeal today. And for that reason, the Industrial Commission plays a special role in this matter, and that role is limited by Evertson, the Industrial Commission of Arizona. Under Evertson, the court held that it would be unfair for the Industrial Commission to defend a winning ALJ decision in every matter, and therefore, if we're defending the agency itself or representing the agency itself, our representation is limited to defending its policies, procedures, and statutory rights.
So basically, you're amicus curiae here.
No, because we believe that petitioner is arguing that the commission doesn't have the right to require documents as part of the 1061J process, and we think that's plainly contrary to the unambiguous language of the statute. We're concerned that the petitioner is arguing that the judge is not within his right to require documentation that would aid in a statutorily mandated determination. We would note that while we take no position on the sufficiency of the evidence that Mr. Montrose and the petitioner submitted as part of their 1061J request, the judge in this case requested that document multiple times, requested evidence multiple times.
Isn't the place to receive that at a hearing?
Pursuant to 1061J, the commission is allowed to investigate and review 1061J requests where it appears from the request that the claimant was not granted benefits to which they were otherwise entitled.
So if we were to affirm in this case, we would be opening the door for discretionary denials of hearings all the time just because the ALJ's eyeballing of the documents didn't impress him or her.
Technically, that could be a possibility. However, we don't see any evidence that this is happening.
Well, not yet.
Not yet, correct. But
At the direction that the commission would like to see things go?
no, that is not. And in this case in particular, the judge was working with petitioner to try to get the information the judge felt was necessary to render the determination required by 1061J. And in fact,
the determination is just, here's the date for your hearing. The determination of the value of the evidence is something that we typically put after or during hearings, not before.
well, if we look at the language of 1061J, there's a three-step process. The first step is that the claimant has to make it apparent to the commission that there's a benefit to which they are entitled that they have not received. And then the second step, if they've provided such information, is that an investigation and review shall take place. We're statutorily mandated to engage in an investigation and review. And then, if the commission determines that payment or denial of compensation was improper in any way, then we refer it to hearing.
That seems to make the hearing, why even bother with the hearing? If you've already decided that the denial was improper, why not just go straight to decision?
In this case, I think what ends up happening is that a couple of very important public policy interests are served by having this, what I will call a gatekeeping function, take place before a referral to hearing. In 2015 and 2016, when we were tracking numbers of matters referred, requests that came in pursuant to 1061J, there were over 1,100 1061J requests made to the Industrial Commission. Out of those 1,100 or so, about 935 were actually processed to completion, and about 25% of those matters were resolved before referral to hearing. So we're talking about a process that is different from a standard hearing request in that it requires an expedited turnaround. We're looking at applicants who are looking for benefits they believe they're already entitled to and they believe they're otherwise being denied. And so in these instances, if we refer the matter to hearing, one, the hearing has to take place much sooner than usual. It has to take place within 60 days of the 1061J request, whereas in a normal hearing environment, typically the matters are assigned to a judge and then must be heard within approximately 90 days of assignment to the judge. So we're talking about a much longer process. So if we take out this gatekeeping function, if we take out the investigation review, which is mandated by statute, that means every one of these expedited requests automatically goes to hearing. We lose the opportunity to resolve before hearing, and we have a much greater caseload that can't be otherwise resolved.
I don't see why you lose the opportunity to resolve before hearing. All of the duties, as I see it, are in the statute. The duty to investigate is there. There's nothing we can do about that or would. The duty to have a hearing is there. What's lacking and what seems to be the core of the disagreement is the standard by which any request for a hearing is to be judged before a hearing is granted. And I don't see anywhere in the statute where the legislature has said you must meet X threshold of proof to get a hearing.
I agree with you. I think
So if the commission were to impose such a standard, it would be doing so without authority, wouldn't it?
No. Respectfully, I disagree. The statute as written provides the commission the discretion to make such a determination. And therefore, if in a medical benefits case a judge believes, or the commission representative that's otherwise reviewing this request, because it doesn't have to be an ALJ, but whoever is reviewing the request can look at the information they're receiving and try to determine whether a benefit is being improperly denied and can request information to aid in that determination. So
what if it's a close call? I mean, here we knew that there was a benefit that was claimed to have been improperly denied, right? And I think the information available to the ALJ suggested why it was being denied. So now there's a factual disagreement. It's either proper to deny it or it's improper. And it seems to me sort of putting the cart before the horse, to put it mildly, to say, we'll make that determination before giving you a hearing. Isn't that the whole point of a hearing?
in this case, because of the expedited turnaround, because of the interest in providing benefits efficiently to claimants that are already...
This claimant feels that she received efficient provision of benefits, and that's the point of the hearing.
Well, and I'll note that in this case, the record would suggest to me that the judge was working with the claimant and the claimant's attorney to get the information that the judge felt was sufficient to refer the matter to hearing. In the decision upon review, the judge noted that the petitioner acknowledged they had that information but didn't provide it. So we see this more as a refusal to cooperate, perhaps, than a denial of access to process.
Well, maybe I can understand how you would have that perspective, but wouldn't it be reasonable to expect that if the judge considers some material relevant, that you come to the hearing and present that material to the judge?
Well, again, I think
it would be a little odd if we decided this case and then decided whether to hear oral argument.
I think that we're talking about two separate processes. I think that the legislature determined that in granting workers' compensation benefits, that it was important that people that were already in the process, that had been awarded benefits, otherwise been found to be entitled to compensable benefits, have this expedited procedure. And they wanted to give them an expedited, a quicker access to the system, but recognized that the demands of such a process could be too taxing. And therefore, they created one process to determine whether it gets into the hearing process, and then an actual hearing process to determine a resolution if need be.
But they never provided. They provided the duty to investigate, but they never provided the means by which to make the determination to hold a hearing.
Well,
there's no if-then logic in the statute. There is a command to investigate and a command to hold a hearing.
There is an if-then built into the statute as we read it. The if is if the applicant makes it apparent to the commission that they haven't been granted a benefit to which they're entitled, then the commission
happened, right?
Well, I think that's questionable in this case too. Although, again,
but again, if it's questionable, don't we go to a hearing? I mean, there was a clear description of the problem, I think, in the request for hearing. Right? I want these benefits. I haven't gotten them. These are the exact benefits I want, and why I think I'm entitled. That was all there.
Not necessarily. And again, I will state that we believe that under Evertson, we can't take a position on the sufficiency of the evidence that was submitted. But for clarity's sake, I think it's worth pointing out that that the benefits to which an applicant is entitled refers to the medical necessity of those benefits. And in this case, Judge Macesso wrote that he felt that these documents did not refer to the positive entitlement to a benefit. It's a fine line. We acknowledge that. But
how fine does it get before it's an abuse of discretion not to hold a hearing? What's the standard?
I don't know that that we can determine what that standard is. However,
well, we have to. Right?
Correct. There is an abuse. There is a process for dealing with abuses of discretion. To respond to the petitioner's point earlier, we have not received complaints, or at least to my knowledge, about abuses of discretion in this setting. The judges typically work with applicants to make sure that that the documents they require are provided, and there's no prejudice to the applicant if the hearing is not set. They can then provide that evidence after the award dismissing the hearing. They can make another J request, is what I should say.
Mm-hmm. Okay, well, throw us a bone here. I know that you're limited in what you can say about the evidence in this case, but what standard does the Commission think ought to apply?
Referring back to petitioner's opening brief, he refers to the petition to reopen and indicates that there's a specific document required in the petition to reopen setting under 1061H, and that is that a medical document be provided. Here, there's no specific requirement of a specific document, only the Commission's determination that it's proper to refer this to hearing because they've determined that payment or denial of compensation was improper in any way. So in this case, I would love to offer a specific standard, but there are lots of variables. There could be medical disputes. There can be disputes over temporary compensation due. And therefore, I believe that we would argue that any information necessary to render a determination that payment or denial of compensation was improper in any way is sufficient.
Wait, say the last sentence again.
We would argue that the information necessary to aid the Commission in making a sufficient determination, one that's statutorily mandated, is what's required in these matters.
So then what happens at the hearing, under your view?
At the hearing, the parties have the opportunity to dispute these issues. So the Commission makes a determination absent argument from the parties before referral to hearing. It determines whether or not there is an impropriety, and then refers it to hearing, if there is. In practice, it would seem that these matters are that the judges. The judge, I should say, just one judge that's reviewing the 1061J request, the judge is looking to see whether there's a plausible benefit to which the claimant's entitled, and then referring it to hearing.
So that's a pretty high burden. Instead of the 12b6-ish standard that your colleague would like to see, you're arguing for a likelihood of success on the merits standard.
That is what the statute requires.
Doesn't see those words.
Well, the statute's third step is that if the commission determines that payment or denial of compensation is improper, then it shall hold a hearing. So the statute, the plain language of the statute would suggest that that there is such a standard before referral to hearing. In practice, I don't think we see that.
Okay. Thanks, that's helpful.
We mentioned earlier that there are important public policy benefits to having this gatekeeping function. The Commission operates efficiently when it can process claims according to the statute. The statute itself is unambiguous. There's plain language, and we believe that when there is plain language, there's no additional analysis necessary. The petitioner's arguments are premised largely on there being no predicate within the statute, but the statute plainly states that there shall be an investigation and review, and then only if the Commission determines that denial of payment or compensation was improper in any way, that the matter shall be referred to hearing. In petitioner's reply brief, he raises she raises for the first time the issue of the Administrative Procedures Act, and that there should be a rule as a predicate to requiring some information before requiring information to make such a determination. Case law runs contrary to that. There's adequate case law that states that information can be required when a party is trying to make a determination that it's statutorily mandated to make. Further, because this is the first time it's being raised, we would ask that it be not be considered as part of the argument in violation of the Arizona Rules of Civil Appellate Procedure. In sum, we think that the language of the statute is clear. It's a three-step procedure. The claimant must make it apparent to the Commission that they've been denied a benefit to which they are entitled. Then, if they make that showing, the Commission shall investigate and review, and we don't understand what an investigation and review would be without some information about the claim. If all matters are referred directly to hearing, then there's no opportunity for investigation and review, and the statutory language becomes superfluous.
Yeah, I'm trying to rescue us from that superfluous language, and I see the language here that you're talking about, but the statute itself leaves us in a quandary, because it says if the Commission determines that payment or denial of compensation is improper in any way, meaning it has already made a determination, then it shall hold a hearing, and it doesn't really say what happens at that hearing. Do we interpret the statute to mean that the determination must happen first, or are we better reading the statute by interpreting it to mean that the Commission needs to find a colorable case before it holds a hearing?
We read it to mean that there must be the statutory language suggests, or actually it doesn't suggest, it says that there must be a determination and then a hearing, and that the hearing would be a full hearing process in which the parties could present their cases, and that the determination itself is something other than an administrative hearing process.
But we don't know what. And by use of the word is, the Commission determines that payment is improper in any way. That suggests some level of finality.
Correct.
Which is odd.
I can't comment on whether it's odd or not. It is the plain language of the statute. In practice, I note again that the judges that I'm aware of that have been in charge of this determination process have been intent on determining that there was a plausible benefit denied, and then referring that matter to hearing if the parties couldn't resolve it. To petitioner's point that this has some sort of greater effect on the applicant's ability to enter the process, we see no evidence of that.
Okay.
Any other questions?
Next time you come, we'll get a longer microphone for you, so you don't have to bend down so much.
I always like the sound it makes as I change the height on the microphone.
Right, that microphone would be above my head right now. Thank you.
All right, we ask that the court affirm the administrative decision. Thank you.
All right. Mr. Montrose, rebuttal?
Thank you. Briefly. From the arguments that the commission have raised, it's clear that they intend to continue to implement a gatekeeper screening process. And not only that, that they argue that they can reserve the right of this screening person to weigh the quantity and quality of documents. And when they're not
without statutory support for that position.
I think they are without statutory authority to require documentation, and that's the core.
Well, but I don't know what it means to investigate if you can't look at documents, and I'll acknowledge readily that the language is, and I'm going to say it again, odd. But when the trigger for a hearing is a determination that the denial of compensation is improper in any way, that suggests more than a 12b6 standard, doesn't it? You don't need the court to determine that the defendant was negligent in hitting your car before you get a trial in a civil case, but you do need that determination here.
Sure. This is how I would offer that the statute should be read and interpreted, and in part, I believe it's applied fairly by the commission in that first step that you mentioned, Judge Swan, the investigation part. Mm-hmm. They performed that investigation here, and what commonly happens is they send my J request to the insurance company, like they did here in the record, and ask for their response. And I think that's the investigation, finding out, did the insurance company know about this? Did they grant this benefit? Is the insurance company going to, tell them and offer or ask that the request be denied because, for example, there's no jurisdiction, or this compensation isn't improper because this isn't the type of compensation covered by the Act.
I want to, in your short time remaining, though, direct your argument to the language of the statute.
Yes.
We get that there's an investigation. We understand that can involve the insurance company. But what about this predicate determination?
I don't think it can stand under the argument, under a standard that the judge is weighing the quantity and quality of the evidence.
It's the legislature said it. Unless you're saying it's unconstitutional, it stands. Question is whether it's ambiguous, and if so, how to interpret it.
It is ambiguous, and I would again say I would ask the court to clarify that it's interpreted similar, if not a more liberal standard than a 12b6.
Where do we find any support for that interpretation in the statutory language?
In the statutory language, you don't. The statute says what it says, and there are no cases interpreting it.
So we would just have to contradict the statute through a published opinion?
No, you can draw upon the other case law that has clarified that the Workers' Compensation Act is supposed to offer a streamlined system, a liberal system, one that imposes, that requires that the administrative law judges and the system have a system of substantial justice, not one of form over substance. So I think if you want to read that literally, then what we have is a denial of due process. I mean, I think that would be, you're right, it would be unconstitutional to not let a litigant have their evidence weighed on the merits by a judge, with a judge listening to the witnesses and evaluating their credibility and cross-examining the doctor's opinion, for example. I don't think that is a system of substantial justice to read the statute in that way.
If is were interpreted to mean may be, the statute would be constitutional, right?
Yes, I think it would be.
And if that's and if may be were the standard, then the Commission's insistence upon receiving certain documents wouldn't contradict the statutory language. It would have to receive some information and determine whether there may be an improper denial of payment.
And I can tell you that in the tens, maybe 100 J requests that I filed and have gotten similar requests from Judge Macesso, who's routinely screening these things, and I have supplied a medical report. And because I had it. In this case, I don't have it. I did not have it. And, there are times when you just don't have it, and it can take weeks to request these reports from medical doctors, and it costs money for our poor, people who are injured and out of work. So, to require that is then to delay their access to justice. And so I think the judge can ask for it, that's fine, but the judge can't then say you're not cooperating, your request for hearing is dismissed. That is an abuse, and that's a system that doesn't serve justice. And, we hear there's over 1,000 of these things. What about the unrepresented parties? I'm here arguing for them too. And are they getting their request for hearing dismissed? I think that's just something that the system should not allow for, and clarification of it would serve us all well. Thank you.
All right, thank you, counsel. We appreciate your arguments. We'll take this matter under advisement. We'll issue a written decision. Court stands in recess.
Thank you.